Fantastic. Thank you so much, Neale. And thank you to Reconnect You. This is such an amazing platform, and I'm so glad to see that so many people are in attendance. Donnie, I absolutely agree with everything that you've said, and I've made notes hastily to just elaborate on what you've said. It's very interesting to see the outcome of the poll in regard to the value that is tied to being a portfolio manager, and that many portfolio managers are seeing themselves as being undervalued. And it leads into what I am going to speak to the attendees about today, and that is specifically the role of the portfolio manager when it comes to dispute resolution. And the topic of reimagining this role is so relevant, especially in light of this quite large movement in the industry towards specialization and really adding a value to property management and to the portfolio managers and their teams. Importantly, one always thinks about a managing agent as being the portfolio manager and forgets about the team that gets them to do their work every single day, from the property administrators to the accounts team to everybody in between. Now, my background as well, that wasn't mentioned, is that I too was a property manager, and I believe that without that stint in my life, I would not have been able to do what I do today. Simply having a legal background in community schemes, I don't believe is sufficient. One has to deal with it on the face or on the ground as well, being a portfolio manager or a trustee, and you're able to actually engage a lot more positively with owners and trustees and portfolio managers, managing agents generally, and other stakeholders in the industry. Now, it was also very interesting to see, I think that managing agents tend to get a little bit more emails than that. I know that I used to, but I also enjoy sending emails. So maybe I just used to generate too much work for myself. But to see that 10% of those emails on a daily basis is to do with legal proceedings and dispute resolution. So it again shows the significance of the topics that we're dealing with today. Now, we all know about the Community Schemes Ombud Service, and we all know that when we have a dispute in the Community Schemes Ombud Service, that is the route to follow. When the legislation came out, a lot of attorneys looked at the wording of the Sectional Title Schemes Management Act and the Community Scheme Ombud Service Act, where it changed from shall to must, and instead of must, there were references to may. And I was always of the opinion that when there is a dispute in sectional title schemes and in homeowners associations and any other type of community scheme, one must go the route of the Community Scheme Ombud Service. Having dealt with the CSOS for as many years as I have, having dealt with clients and their expectations and outcomes of these proceedings, I have changed my opinion of the interpretation of may to mean just that, may, as opposed to must, and to refer matters either for internal dispute resolution, preferably, or to court proceedings. Now, when it comes to court proceedings, very often the courts believe that one first has to exhaust your internal remedies and go the Community Scheme Ombud Service route. But most importantly, one needs to look at those internal dispute resolution proceedings. I've found that when we circulate rules or submit rules, once they've been amended to the Community Scheme Ombud Service, they come back and they specifically require an internal dispute resolution process to be set out in the rules. That just again shows the importance of it, that they will not approve a set of rules without this internal dispute resolution process. And what is that? It really depends on the type of community and the type of individuals, which is why we are also of the opinion that rules are a working document and they change depending on the occupation, the ownership, the needs and the desires of the scheme. Now, when one makes an application at the Community Scheme Ombud Service, interestingly, one of the requirements that are needed to be met is to provide evidence that an internal dispute resolution process has been followed. The CSOS calls it that you have exhausted your internal remedies. And 9 times out of 10, when I receive these applications, very little has been done in the way of internal dispute resolution. Perhaps a couple of emails have been sent, a request for a meeting has been sent, maybe a meeting has been held, but that's pretty much it. And until today, we still don't have clarity as to what the CSOS means when they speak about exhausting our internal remedies. Is it simply sending emails backwards and forwards? Is it trying to arrange a meeting but failing? Is it trying to get support of your fellow members and calling a special general meeting? I believe that it's all of those. One cannot approach the Community Scheme Ombud Service if you have not attempted in a reasonable manner to try to resolve the matters internally. Very often people don't know what this is, and that is why it needs to be set out in the governance documentation of the community scheme. Now, the portfolio manager most certainly has a role to play when it comes to the preparation and amendment, and most certainly the enforcement of the governance documentation, and in such the internal dispute resolution process as well. I think this is still a relatively new concept in sectional title schemes, simply because we always used to have the routes of arbitration and now have the routes of the community scheme ombud service. I find that in the governance documentation, constitutions and memorandums of incorporation, that the provisions of internal dispute resolution is a lot more clear in homeowners associations. They speak about perhaps having a disciplinary committee being set up, having both trustees and directors and interested members, perhaps the portfolio manager, the estate manager, having procedures for notices and warnings needing to be applied, opportunities to meet, opportunities for meetings to be rescheduled, opportunities for decisions to be taken to the members, and then of course ultimate consideration in line with the governance documentation as to the enforcement of any penalties and attempts at dispute resolution. There isn't a lot in community schemes that we can do to ensure that disputes are resolved. Community scheme living is known as the mother of all disputes, interestingly, and one can imagine that that is very much the case in practice. When it comes to internal dispute resolution, like I said, the governance documentation has to give us an indication of how this needs to be done. When we prepare these types of clauses in our governance documentation, we do attempt to allow the portfolio manager to have an input in this process. And I would like to talk about the value add that this has. I remember in my days working in the sectional title department with Marina at BBM, when it came to levy collection matters, we used to ask the portfolio manager to be the one to depose to the founding affidavit for the legal proceedings, because it was the portfolio manager that had that intimate knowledge of the day-to-day administration and management of the body corporate, of the homeowners association. That is exactly the case when it comes to dispute resolution as well, because is levy collection not a form of dispute resolution in any event? It is the portfolio manager that was in attendance at a meeting, that recorded the minutes, that had all of the correspondence, that had the telephone call with the upset owner, that engaged with the trustees, that listened to the reasons of the trustees when it came to enforcement of fines and penalties, that received the application for renovation work that has gone awry, or for a pet application that has not been agreed to. All of these things that happens in sectional title and homeowners association when we talk about disputes. So why should the portfolio manager not have the prime role when it comes to dispute resolution? I find in my personal experience, as well as working with my portfolio manager clients, that very often the portfolio manager is simply assumed to run with or lead or manage the dispute resolution process. And as Donnie mentioned, their low fees very often, again, are simply assumed to include this specialized field, a field that is conducted by people such as myself and other consultants and attorneys in the industry. Why should the portfolio manager, the managing agent company, take on the time, the resources, have the necessary skill set, and then of course assume liability and responsibility should anything go wrong, either through their fault or no fault of their own, very often, for no additional fee? Very often when I was a portfolio manager, before I started practicing as an attorney, I used to do all the legwork for an attorney to simply sign off on it. And it used to be incredibly frustrating that I used to give the same quality of work without having the recognition and without being able to charge the fees. Why should that be the case? One doesn't necessarily need to have a legal degree in order to deal with internal dispute resolution or even dispute resolution at the community schemes ombud service. One simply has to have the intimate knowledge of the day-to-day affairs of the community scheme, know the individuals, act in good faith, and most importantly, know the governance documentation and the relevant legislation of the community scheme that they're working with. Is that not the skill set of every single portfolio manager in any event? Now, the problems that arise with the portfolio manager running this process or being seen as the representation of the body corporates is that very often the portfolio manager is recognized as being a pseudo legal eagle, but unfortunately they can't bill for their time. So they are often not accepted as being the representatives of the body corporate or the homeowners association. They are seen as placing the parties on an unequal footing, but at the same time, they don't get the recognition for it. Now, this is a difficult situation to be in because a portfolio manager, managing agent, acts for the community scheme. They enter into an agreement with the community scheme. However, they act on the instructions of the management of the day, the trustees or the directors in the case of a homeowners association or a share block company. Now, it is incredibly, it's a difficult position to be in because if one does not do right for one person, one is in trouble with the other. And when it comes to a portfolio manager's role, they are often seen as taking the side of management, the people that they report to. And at the same time, they cannot risk alienating any owner or group of owners because very easily they could become the next committee of trustees or directors. And I see often in these CSOS matters that along with the prayers that the owners or the tenants are asking for against the management of the scheme, at the same time, they're including the managing agent, and they are requesting that if matters don't go their way, that the managing agent has incorrectly advised the trustees or directors. The managing agent needs to be removed because the outcome is not what the applicant has hoped for. And the same is true for the other side. If the proceedings do not go the way of the trustees and directors, again, the managing agent is placed at risk of being terminated because of that. So it is a role of responsibility and liability that they take. And for that alone, they should be ensured that they be remunerated for those services. It is a tough task and very often it's a difficult calculation to make. But if portfolio managers and the managing agency or property management industry as a whole is going to be seen as professional, they do indeed, as Dani said, need to be specialized. And for that, they should be able to recover for their time and for their resources. Now, if managing agents do get as many emails and more, one can imagine between that, the meetings, the traveling, and dealing with telephone calls and distractions in the office and not, there isn't much time left to deal with disputes and the backwards and forwards and the preparation that comes with it and the timelines that are set by the Community Scheme Ombud Service and dealing with written submissions and everything that comes along with it. And unfortunately, the procedures at the Community Scheme Ombud Service have also complicated matters that one can no longer engage with each other, which in my opinion is always the best route, but simply to put one's thoughts down on paper and to motivate it. And that takes time, and a portfolio manager very often doesn't have the time. If they are able to be recognized for their role in dispute resolution, if that role indeed can be reimagined and accepted, most certainly they can then make the time to ensure that they take that role very seriously for their own benefits as the company providing their service, and of course for the community scheme that they manage. I don't believe that there is anybody better suited to deal with a dispute, at least in conjunction with trustees and directors, than the portfolio managers themselves. We've spoken a lot about the Community Scheme Ombud Service. Let's get back to internal dispute resolution, because I do see that that is the way of the future when it comes to community schemes. Internal dispute resolution, firstly, needs to be set up that everybody is on the same page. And a portfolio manager is most certainly well suited to be able to facilitate a resolution or a settlement of a dispute. My previous employer, when I was a managing agent, always used to say that resolution is when both parties walk away from the deal equally unhappy. And I always used to think that that was quite a strange saying, but dealing with with disputes more and more, I do see that there really isn't a winner and a loser, and both parties do tend to walk away relatively unhappy. And I think that is ultimately the resolution. One is not always going to get what one wants, and there's always a catch at the end of the day. And when it comes to community schemes, even if you are the winner financially, you are still the loser financially, because you have to contribute towards the expenses of that community scheme. So one has to find a happy medium, a middle ground, and the portfolio manager is the one that is best suited to be able to do that. They are the ones that know the individuals that are parties to a dispute, be it an owner, be it a trustee or director, be it themselves, as far as the Community Scheme Ombuds Service refers to them as being a party to an application or to a dispute. There is, of course, that concern of how it is going to affect their management status or their agreement or relationship with their scheme. And this type of service should be incorporated into the management agreement, along with the costs and the terms and conditions associated with it, and perhaps some issues about responsibility and indemnity as well. And in order to fulfill this role, of course, they should be allowed the opportunities to partake in training, such as today's event, to be able to equip themselves and to ensure that they are confident in taking on this type of role. I know that a lot of portfolio managers very often take part in these types of proceedings and walk away from it saying, I could do that, or even better, I could do that better. And we are wanting to equip portfolio managers, reimagine their roles, that they are in fact able to do it better for the benefit of the community scheme and, of course, for the benefit of themselves. Now, for the internal dispute resolution process, I believe that a meeting is always the best way forward. One can no longer use the excuse of COVID and all those fun things to not meet. We've got resources such as the Zoom platform that we're on today to actually entertain or to facilitate a meeting, to give both parties an opportunity to put their side of the story forward, to interject if needed, if the facts don't line up. And that is something that we don't often have during the process of conciliation or adjudication at the Community Scheme Ombuds Service, or in arbitration proceedings in an HA, or even in legal proceedings via court. It is important as part of that internal dispute resolution to be able to put the facts on the table and to support it. And who better than the portfolio manager to do that, being the ones that are in the meetings, taking the minutes, preparing the resolutions, being there firsthand and listening to the outcome of resolutions, the justifications and reasoning behind it, dealing with the owners, being in the correspondence, if not the main role players in correspondence, knowing the scheme, not only from a governance perspective, but the actual practical realities of the scheme as well. Rules are one thing, but the practical application of it is very different. And that is the importance of having a portfolio manager and, of course, being part of a process like this, knowing the practical realities of the scheme. So being able to facilitate, being able to correct where necessary and substantiating it, knowing the people that they're dealing with, and importantly, knowing how far a matter can be taken. One doesn't want to spend hours and hours attempting to resolve a matter and at the end say something that is going to upset the people that are party to it from the start. And the portfolio manager knows the people in the community scheme, both from a management perspective and owners and tenants. Communication is vital. And very often we see that disputes arise because there is no transparency or communication. And again, who better than the portfolio manager to ensure that those communication channels are open? Often in our governance documentation that we prepare for our clients, we put in a line of communication or the communication process to ensure that there is one channel, a formal process, and that everything from complaints to requests for dispute resolution and everything in between goes through that one communication channel, which in most instances is the portfolio manager. I again said to a client yesterday, something that I learned as a portfolio manager is that we're the ones that are paid to put on the bulletproof vest. But bulletproof vests are expensive, and we need to ensure that the fees that we're getting, especially for these additional specialized services, are such that we can afford the best quality bulletproof vest in order to assist our clients and the owners, which are our clients as well, not just the trustees and the directors. And most importantly, and something that I would like to end off with, is knowing as a portfolio manager that you can say no. You can tell the trustees and directors that what you're doing here is wrong. We always used to tell our team members, make sure that you've got it in writing, make sure that you've ensured that what you've said is in writing, that if the trustees and directors turn around and say, why didn't you tell us, that you can say, yes, you have, that you can protect yourself. You need to be able to prove that you have guided and advised your directors and your trustees and your owners. And very often as managing agents, you have that in your management agreements, that you do in fact offer the services of advice and guidance, and that you put yourselves forward as experts or specialists. If you're going to do it, you have to act like it as well. And very often as portfolio managers, we're afraid of saying no. We're afraid of standing up to the trustees and directors and owners, especially that one or two difficult owners in the scheme, and say, what you're doing now is wrong. What you're doing is in contravention of the Act. We are quick to say we're going to take instruction. Attorneys do that as well. But at the end of the day, you are going to be held accountable as well, if not in terms of your management agreement, in terms of any outcome that comes from an internal dispute resolution process or the community scheme ombud service. One has to make sure that you are guided, if not by a statutory code of conduct, at least a code of conduct that you set for yourself, bearing in mind that all the functions of the trustees and directors fall on your shoulders, and very often that liability as well. If you are going to lose a contract or two out of the deal, which is likely, people don't like being told no, it is a possibility. And you have to set yourself up for that. And I've spoken to many portfolio managers, many managing agents that are fearful of losing a big contract and the impact that it might have on the business. But is it not more important to ensure that your level of integrity, and of course that you've made sure that you've done the right thing in terms of the legislation, the governance documentation, and your management agreement, and that you've done right by your company and your reputation to ensure that disputes are dealt with correctly, that the law is enforced correctly, that the governance documentation of your schemes are enforced correctly. And of course, you can say no if you don't have that confidence or capability. A portfolio manager is meant to be the jack of all trades, and at the same time needs to be the master of all as well. We often used to joke as portfolio managers that we are plumbers and electricians and psychologists and psychiatrists and engineers and all sorts, because that's what our clients expect us to be. But we cannot be that at all times, because we are going to be held responsible and accountable for that. So if you do need to outsource that expert's advice, you need to feel comfortable to do so. And again, that leads us to the discussion of the costs and the fees, because your clients are going to turn around and say, but isn't that what we're paying you for? No, it's not. As a portfolio manager, you're not expected to know it all. And that takes us all the way back to the beginning of the circle of portfolio managers in the industry of property management. Most certainly does need to be specialized and recognized as specialized, especially in the delicate balancing act between owners, trustees, and directors or management when it comes to dispute resolution and a successful outcome, or at least success in that both parties walk away equally unhappy. Neale, thank you very much for the opportunity. I look forward to any questions that we might receive at the end.